Thank you, everyone. We're getting to start our third session today, which is titled Sieges, Blockades, and Starvation. And we're going to delve deeper into real practices and acts and things that are going on in terms of IHL. Our first speaker in this panel will be Dr. Uchier Bartels. Did I pronounce it correctly? Good. Uchier is a legal officer in the chambers of the ICC since 2019 and 2020, respectively. He's also a part-time judge in the District Court of Amsterdam and part-time appeal judge at the Court of Appeals in The Hague, where he sits on domestic criminal trials and extradition cases on an occasional basis. He's an expert of international criminal law and international humanitarian law and the intersections between two bodies of laws, and he will open this panel and lay down the, I think, legal and theoretical normative questions that further questions will delve into. Thank you.
Good afternoon, everyone. Welcome back from lunch. I'll hope to keep you from your after lunch dip. I need to start with a thank you to the organizers. I'm very happy to be back here. In this regard, actually, I counted earlier this morning, and this is my 7th conference here that I'm speaking. But it's the first time that I can be introduced as a doctor. Last time, Danny, hopefully as a joke, actually remarked that how many more times they had to put me on the program as a PhD candidate as opposed to someone who had actually finished his PhD, despite 2009 being the first conference I spoke in. As I need to also, based on my CV, how it was explained by Tamar, I need to make the general disclaimer, whatever I'm saying here today, but not just now during this talk, more generally what I say whilst being here are my own views, not those of one of my employers. All right, so siege warfare. It's a very ancient phenomenon. It's already reported in the Bible that this very city, Jerusalem, was supposed to have been conquered by King Nebuchadnezzar, after a siege of 1.5 years. But albeit an old phenomenon, it still takes place today. It's not something of the past. So recent conflicts in Syria, Yemen, have seen siege warfare being conducted, and that's why it's relevant to discuss it today. A few months ago only, we have all been able to see, most of us on TV and some of us in this room from a lot closer by, how Russian forces laid siege to Mariupol. Now, historically, siege warfare, during which the entire population of a location or a city was subjected to starvation, was not prohibited, and indeed it was generally practiced during armed conflicts, even though they weren't called armed conflicts, wars, so to say. Even at the time of the Libre Code, so that would be 1863, so shortly before modern international humanitarian law treaties came into existence, it was suggested that the throwing of the burden of war on the disloyal civilians was permitted, and as was, according to Libre, the starvation of hostile, belligerent, armed or unarmed persons, civilians. A few decades later, the Hague regulations did prohibit pillage and mandated that certain buildings may not be fired at during a siege. But these rules did not address at all the persons who would be subjected to a siege. And shortly before the adoption of the 1949 Geneva Conventions, the US military tribunal in Nuremberg, so the Control Council 10 Tribunal, in the von Leydt case, or most will know that as the High Command case, confirmed that at the time of World War II at least, siege warfare was entirely legal, lawful. The judges, they did express their regret in the judgment about not being able to find otherwise, but they said that the German use of artillery to prevent civilians from fleeing the siege of Leningrad was not a war crime, or could not be prosecuted as a war crime. Well, since then, we have many new IHL rules that have been agreed upon, the most relevant ones, of course, in Additional Protocol 1, and customary IHL has expanded considerably. And in this talk, I want to consider to what extent this classic, this ancient concept of siege warfare can still be employed in a legal manner during contemporary armed conflict. So that is whether a party to an armed conflict can still lay siege without violating any of the rules of the current version of IHL. It's black letter or customary. Or whether instead maybe any siege would nowadays necessarily violate IHL, albeit maybe just one of the rules. Now, in doing so, I'll first discuss what we actually must understand as a siege, and then discuss the two components of siege warfare. That's the attacking of an area by means of bombardment, for example, with artillery, and then the other component, the starving of civilians, or not civilians, the starving of persons, I need to make a distinction here, within the encircled area to enforce surrender, and whether this can be compatible with IHL. Well, given my work at the court, you will understand that I will not draw explicit conclusions about the Russia-Ukraine conflict, but I will give examples also of this conflict, and as well as other situations, and then you can draw your own conclusions. Now, what is a siege? So the term siege, it derives from the Latin word sedere, which means to sit, for those who had Latin, or that goes beyond the typical terms that you find in international law or criminal law. Although you have provisions of IHL that refer to something being besieged or encircled, there's no actual definition of siege in IHL. And even though it's been practiced throughout history, there's no term, the term siege is nowhere defined in international law generally. Now, military tactics do define a siege. So they say that a siege is understood as the military encirclement of a town, city, or a military installation, or an area of land in order to impose isolation on the enemy, to enforce surrender, or reduce resistance to enable takeover. So with a siege, the enemy or the besieging army seeks to compel surrender, reduce the adversary's resistance, or lay the basis for an assault by encircling, isolating an area by effectively cutting it off from its essential supplies. Now, we all know there's famous sieges in history. I already mentioned one of Jerusalem, but we know the Iliad, how Homer describes the siege of Troy, and that seems a bit unrealistic, 9 years, but if you know that the siege of Leningrad took 2.5 years, it's not even that, other than maybe the involvement of the gods and all the other things, it may be not even that unrealistic. During the wars that led to the Peace of Westphalia, there were entire cities that were besieged, sometimes for years. And in the past century, I already mentioned Leningrad, but there's other famous encirclements where the sieges of Sebastopol, Lille by the Axis powers, or the siege of Dunkirk by the Allied forces. And one lesser known, but actually very interesting siege is the one of the naval siege of Malta, which was conducted purely by naval forces by the Axis powers. Now, more recently, in the 1990s, I don't want to say all of us age-wise, but a lot of us may have seen on TV the sieges of Grozny and Sarajevo being reported, getting a lot of media attention, and for the first time really showing on TV the plight of the civilians who were trapped in these cities. And if we think about Sarajevo, it actually shows that for something to legally qualify as a siege, it's not necessary that an area is entirely encircled, that no one is allowed to go in and out. Sometimes it's geographically impossible, like Leningrad had on two sides of water, for example. But you can have a siege, legally speaking, without a complete isolation. Not only this is evident from the relevant articles of the GCs, so that's 15, 18, 17, respectively, of the first, second, and fourth Geneva Convention. Obviously, the third doesn't have a article related to sieges. Because these articles, they refer to besieged or encircled areas. And the siege of Sarajevo, which was subject to a few ISTY cases, Yugoslav tribunal cases, was considered to be a siege, whilst actually, and this was also acknowledged in the Dragomir Milosevic case, it was not a siege in the classic sense, because civilians and what they refer to as combatants, although technically maybe were fighters, but anyway, they were able to leave the city. There's actually even an entire ISTY case, the one against Nasser Oric, which deals with ABIH forces, so the Bosnian Muslim forces in Sarajevo conducting attacks on villages, Serbian villages outside Sarajevo. Still, this was qualified legally as a siege. Now, can such a siege be legal nowadays? So there's two sets of rules relevant to sieges. First, those related to the conduct of hostilities, what and who may be attacked during a siege. And then there's a second set that deals with those in the besieged areas. That's the prohibition of starvation, rules on humanitarian relief, and evacuation. And with the first set of rules, it's not just bombardments that must follow the targeting rules. Any attack during a siege must be directed at a military objective, not be indiscriminate, and comply with the proportionality rule. That's you can find in AP1, but which are also customary. So any attack that's also sniping, and it was especially sniping that became like famous or infamous during the siege of Sarajevo. And obviously, precautions also have to be taken. Now, the thing about a siege is because of the confined environment in which not only those, so the ones who are besieged, so that's not only combatants or fighters, but also civilians, they find themselves in very close proximity to each other. So complying with the targeting rules creates a lot of practical challenges for the besieging forces, the ones who are attacking. And these challenges, they may be similar to what was discussed this morning by Marco, like the use of explosive weapons in urban warfare. Well, this is on the agenda now of states. He already referred to Ireland, conflicts taking place there. But it doesn't make it any, the fact that this is now on the agenda doesn't make it any less relevant in the context of sieges. Now, the oldest IHL treaty provision on sieges, Article 27 of the 1907 Hague Regulations, it already set out the obligation to spare specifically protected civilian objects, such as places of worship. But nowadays, of course, we know under contemporary IHL, any civilian object is protected, and you can't attack so long as it doesn't become a military objective, as was earlier discussed also today. But and then there's also a change if you look at what I said in the tribunal in Nuremberg, that it considered that attacking civilians that were trying to escape a siege was considered legal at the time in 1948. And actually, until very recently, US military manuals still considered this to be legal. The newest DoD manual and the new version of the field manual 627, they now explain that that using force to push civilians back into a besieged locality is actually unlawful by now. Now, if there's no civilians present to a siege, and if the besieged area is really only just a military facility with only combatants or fighters, then it's easy. A besieged force can basically do what it wants, so long as it doesn't use prohibited weapons, such as biological ones. But generally, there will be at least some civilians present, or otherwise affected by what is conducted during the siege. In Ukraine, we recently look at the Azovstal, the steel factory, which is a bit like a modern castle, but not thick walls, but just very thick metal structures. There, until they were at the end allowed to be evacuated, initially there were also civilians present. So it was a mix of both combatants and civilians. If there are civilians, of course, distinction proportionality, they are relevant and they have to be taken into account. And because of the particularities of sieges, when considering expected collateral damage, you have to bear in mind that any injuries, for example, may be harder to treat. There may be no hospitals left or fewer hospitals left. Maybe less medical supplies may have run out. And if people cannot leave, of course, any damage to civilian property, civilian objects will have a bigger impact on the civilians. They can't move to alternative shelter, or they can't acquire materials to rebuild destroyed homes. On the same counts for other items that the civilians rely on for their survival, such as drinking water facilities. And arguably, the longer a siege lasts, well, this is not argued, the next point will be, but the longer a siege lasts, the more important things like drinking water facilities become, and the greater the effect on the population if they're damaged or destroyed. And during a siege, arguably, the military advantage cannot change throughout the entire siege, but the expected incidental damage would likely increase as time goes by. Now, with regard to the targeting restrictions, obviously also specifically with the siege Article 51.5a of AP1, which says that you can't treat several military objectives as one larger military objective if it's mixed with civilian objects. That's a very important one, unless, as Marco mentioned, of course, in relation to Mariupol, if you were to accept that every single house had become a military objective, then if everything is a military objective, okay, then you don't have to make a distinction anymore. But otherwise you do, and you're never allowed to just treated as one target. In this regard, as treating something as one, like it's been suggested that the principle of proportionality applies to a siege as a whole. And there's scholars who argue that an attack, for the purpose of Article 49 of AP1, that applies to a siege. And as a consequence, the siege itself would be unlawful if the overall expected civilian harm from a siege as a whole would be excessive to the concrete and direct military advantages anticipated by the laying of the siege. I do not believe, or I don't view a siege as an attack in the sense of Article 49, but it doesn't mean that the principle of proportionality is not still relevant. It's just not a proportionality rule. Because the principle is broader, and it applies not only to an attack, but it applies to all military actions, and it includes not only attacks, but it also includes blockades, for example. In fact, the new US DoD manual accepts that proportionality must be taken into account during not only blockades, but also sieges. Now, as regard precautions, attackers naturally must take precautions in their choice of weapons, especially if you have the civilians and fighters or civilians combatants mixed in close proximity to each other. But defenders must also endeavor to remove civilian objects under their control from the vicinity of military objectives and avoid locating military objectives within or near densely populated areas. You will know that was discussed this morning. Article 58, AP1. But this must be done to the extent feasible. And Marco already mentioned this morning, there was a big discussion, or shitstorm as he referred to it, earlier this year when Amnesty International questioned Ukraine's adherence to Article 58. And as an obligation, this obligation on the defender under 58, it's obviously, if you look at the feasibility, it's very hard to locate military equipment elsewhere if you're in a encircled area where everyone is next to each other. So it might be difficult to relocate something, but be that as it may, of course you cannot deliberately move objects to next to a military objective, next to a civilian object in order to shield the military objective from attack. But then in the end it becomes very context specific and you'll need to actually know what the situation is. Now, if you consider these conduct of hostility rules, clearly it's not easy for a besieging army to comply with IHL when laying a siege if you attack. But the whole point of a siege is that you don't necessarily need to launch any attacks. In the classic sense, a siege was, they wanted to preserve the armed forces by starving those in the besieged area of supplies or food. And as Johan Dinstein said, the essence of siege warfare lies in an attempt to capture the location through starvation. And actually, historically, we see those things in movies that they climb up the walls of castles with ladders and then they get hot oil poured over themselves. Normally, that didn't really happen, or very rarely, because that would just mean that the besieging force would lose a lot of forces and not really gain much with it. So what they did, they would starve the ones in the castle. But nowadays we have rules for starvation. Starvation of civilians as a method of warfare is prohibited, and the concept of starvation must be given a broad interpretation. So it's not just food or water, but it's also other goods essential to the survival of civilians. So in cold places, this may be blankets or wood or heating oil. And it could also include medical supplies, but then there are separate provisions related to the rules of the treatment of wounded, because if there are wounded or sick civilians or fighters in need of treatment, the besieging forces must actually accept offers to remove these persons from the besieged area. Separately, they must also allow for and facilitate rapid and unimpeded passage of medical supplies and equipment. I'll leave aside for the moment Article 41 or 54.2, the object indispensable for the survival of civil population, because we have discussion later on scorched earth tactics. And now starvation sounds extreme, and under IHL the threshold is actually, the word starvation sounds extreme. The threshold is pretty high. It's not mere hunger or not having adequate supplies that immediately amounts to starvation. So it doesn't immediately arise. There's a certain period, of course, before that takes effect. But if starvation is basically a standard byproduct of a siege, then, and you're not allowed to starve, the whole point is that if you want to starve the besieged forces, the moment you let in food, you don't know if it will actually go to the civilians only or also end up with the besieged forces. You're basically prevented from carrying out a siege in the classic sense. So does that mean that that the prohibition of starvation means that any siege in itself is unlawful? Well, Anthony Rogers, in his book, The Law on the Battlefield, so he considers that it's still possible so long as the besieging commander has allowed the safe passage of the civilians and the wounded and sick out of a besieged area. And the UK Manual on the Law of Armed Conflict, which incidentally was written also by Rogers, appears to conclude that incidental starvation of civilians as a result of a siege is permitted if all practical steps have been taken by the besieging commander to allow civilians, persons hors de combat, to leave the area during the siege. Dinstein questions himself whether, indeed, if civilians are either coerced to stay or they're not, or they refuse to stay, whether this would prevent then the besieging forces from sealing off the area completely and effectively then subsequently starving them. He poses this as a question, but I don't actually believe that the answer would be that it is then permitted. Because in case of a besieged cities or areas, the parties have to endeavor to conclude agreements to remove the wounded and sick and civilians. But civilians may not be forced out. And 54.2 on the forcing out of civilians is also very clear. So if the besieged area creates corridors, otherwise permits civilians to be evacuated, but the civilians remain present, either because, like Mosul, when ISIS prevented civilians to leave, or civilians just choose to stay in their houses, that does not make them voluntary human shields that do not have to be taken into account anymore, for example, for proportionality, but it also doesn't mean that the starvation prohibition no longer applies. So long as civilians are present, they must be taken into account. And a general prevention of food and other supplies would then mean that it's a violation of the prohibition to starve. So that means it's nowadays basically effectively impossible to carry out a siege unless you only have combatants present at some point, which may be because the civilians leave or because they were initially only combatants or fighters present. Now then, to close off, there's a question whether it's okay to then starve combatants, whether that's in line with IHL, because it's not prohibited specifically in relation to combatants. And because you're allowed to attack these people, you would assume you may also starve them, but then there may be the question whether or not starving them would be superfluous injury, causing superfluous injury to them or unnecessary suffering. I don't believe that would be the case, because they don't have to die from hunger. In a normal situation, all the defending forces have to do is surrender. The moment they surrender, they become POWs, and they have to be treated humanely, and they have to be fed. Obviously, this all assumes that the defending forces can surrender without knowing that they would, for example, be killed or executed. But let's take that aside, because then the bigger issue is not the starvation, but is, of course, the fact that this may constitute genocide, as it was in the situation in Sarajevo, in Srebrenica, where the Bosnian Muslim forces did not dare to surrender because they had seen what had happened to those who did. So if they have the chance to surrender, I don't think that the starvation of the combatants in itself would constitute a violation of IHL. So in that narrow circumstance, siege warfare in the classic sense can take place, but otherwise, in all other situations, I would consider it to be contrary to IHL. Well, and even though that's not a very cheerful note, I do hand the floor back now to.
Thank you very much. Our next speaker is Anna. Yep. Anna Mikitenko, who is a senior advisor to the Ukrainian country manager at Global Rights Compliance Foundation. Anna advises Ukrainian state authorities and organizations on the investigation and prosecution of international crimes. Currently, Anna is part of the Mobile Justice Team project, which is designed to help the investigators and prosecutors in Ukraine with their efforts to bring justice and accountability to victims of international crimes committed during the full-scale Russian invasion. Thank you.
Thank you. Before I start, let me just note that much of what I will say in the next 20 minutes comes from the research that's laid basis to the blog co-authored by myself and my brilliant colleague Maxim Vishik. Of course, I will shamelessly promote it, not the first time today. It's titled, All Our Hope is in the Famine. And if you don't fall asleep by the end of my speech, you will know why. Today, I will focus on patterns of starvation as a method of warfare in Ukraine. Surely you've all heard that the war against Ukraine put millions in Africa and other states on the brink of starvation. What is less spoken is that 10.2 million in Ukraine, once breadbasket of the world, require urgent food and livelihood assistance. Of course, this is not to say that the crime of starvation is indeed taking place in Ukraine. Publicly available information is not sufficient to make a firm conclusion. However, an urgent investigation into this crime is required. And this is because several types of Russian attacks, which I will discuss in the next 20 minutes, arguably form patterns of conduct indicating an intent to cause starvation of civilians. To be clear, I'm of course speaking from the practical perspective, having an opportunity to observe these attacks and their effects as part of mobile justice teams that we mentioned earlier. Since Russia's full-scale invasion of Ukraine on 24 February 2022, reports emerged of using starvation as a method of warfare. A broad range of tactics employed by Russia could potentially fall under the definition of starvation, including sieges, obstruction of humanitarian access, pillaging of agricultural machinery, and shelling of civilian infrastructure, as well as shelling of crop fields, grain silos, grocery stores. While some of these acts might, on the face of it, amount to war crimes in and of itself, others are less straightforward. Considered in totality, however, these acts do raise allegations of the use of starvation as a method of warfare, as prohibited by Article 54.1 of the Additional Protocol 1 and Rule 53 of Customary IHL rules. Now, let's explore the variety of the aforementioned tactics to identify any patterns of conduct and assess whether such patterns might amount to a war crime under Article A2B25 of the Rome Statute, i.e. intentionally using starvation of civilians as a method of warfare by depriving them of objects indispensable for their survival, including willfully impeding relief supplies as provided for under the Geneva Conventions. In line with the Rome Statute element of crimes, the discussion will evolve around two central questions, namely, one, whether the Russian forces deprived civilians of objects indispensable for their survivals, or OIS, and here we will analyze various types of incidents moving in chronological order from sieges, most notably that of Mariupol, and obstruction of humanitarian access to attacks on food infrastructure and targeting of power plants and water installations. And second question is, of course, the intent to starve civilians as a method of warfare. Let me start with the definition of OS. Under Article 54.2 of the first additional protocol, these include but are not limited to foodstuffs, agricultural areas for the production of foodstuffs, crops, livestock, drinking water installations and supplies, and irrigation works. The list is non-exhaustive and depends on the context and prevailing circumstances. OS can include any civilian essential, as was mentioned, such as medications, clothing, blankets, means of shelter, gas, fuel, electricity. And of course, it's only logical to assume that in Ukraine, where temperatures sometimes reach 20 degrees negative in winter, the definition of OS indeed includes these items. Warring parties are permitted to attack OAS in circumstances ranging from if OAS are used solely by the enemy's armed forces, if deprivation of them occurs in direct support of military action and is not expected to leave civilian population with such inadequate food or water as to cause its starvation or force its movement, if such attacks are pursuant to an imperative military necessity, and pursuant to the use of sieges and blockades provided they imposed with a view to gain a military advantage. Analyzing the elements of Russia's conduct, let me attempt to demonstrate how the means and forms of deprivation of OAS change as the war progresses and seemingly failing to meet any of the listed lawful purposes. Firstly, in the early phase of the war, roughly in February-March of this year, Russia employed siege tactics in several areas, most notably in Mariupol, but also in Chernihiv, Sumy, and Kharkiv regions. Simultaneously, it blocked humanitarian efforts to bring relief to civilians in besieged areas. To quote David Beasley, executive director of the UN's World Food Programme, "We can't reach them, we are blocked, we can't get into the besieged cities like Mariupol, Mykolaiv, and Kherson, and I could go on and on. They have to be starving." For the sake of saving time, I will focus on Mariupol, which is a bright example of blockade which deprived civilians of means to survive. Almost immediately after the full-scale invasion commenced, the residents of Mariupol were blocked from leaving the city. This is despite that between then and May, the city remained under incessant bombing, missile, and artillery attacks. At the same time, humanitarian aid convoys that attempted to bring relief were either blockaded, looted, or both in violation of the Fourth Geneva Convention and First Additional Protocol, as well as customary IHL. As a result, in early spring, when the weather was still cold and snowy, many civilians in Mariupol lost their homes to bombing and shelling. Central heating system was destroyed beyond repair. Electricity and water were cut off. Those who survived bombing did not have safe access to food and water. 3 weeks into the siege, people in Mariupol were, and I quote, "so hungry they killing stray dogs for food," end of quote, and drinking snow. This is one, although the worst, example of a siege which occurred when it became clear that Russia could not achieve quick territorial gains. Of course, as we've just heard, IHL does not prohibit sieges. What it does prohibit, and what could be observed in Mariupol, Chernihiv, Sumy, and Kharkiv regions, are deprivation of OAS and obstruction of humanitarian access. Similarly to Syria and Yemen, siege tactics employed in Ukraine suggest a policy of attacking civilians until they submit to the enemy's authority. Sieges, however, take a long time, and as can be observed in Chernihiv and Sumy, may not be successful, thankfully so. This is why another instrument seemingly used by Russia to achieve desired military outcomes is indiscriminate shelling and/or targeted attacks on civilian objects and food infrastructure. To put it simply, it appears that Russia wipes out the cities that it cannot otherwise win over. This is especially true of eastern Ukraine, where places such as Lysychansk, Severodonetsk, Rubizhne, Liman, so on, are largely destroyed. Obviously, such indiscriminate shelling cannot but cause damage to or destruction of civilian objects. The existing reports suggest that dozens of thousands of civilian objects became the objectives of military attacks since February, including schools, kindergartens, hospitals, and residential buildings. It would be ridiculous, as we know, to assume that all of these incidents amount to violations of IHL or war crimes, but let me focus on hospitals as such that are most essential to survival of civilians and food infrastructure. As of early November, World Health Organization's surveillance system for attacks on healthcare documented 643 attacks on healthcare in Ukraine. The examples here range from a well-known attack on the maternity hospital in Mariupol on 9th March to those less covered in the news. For instance, on 11th March, Russia tank fired at a geriatric facility in Kremenna, Luhansk region, killing 56 persons. Also in March, Russian forces shelled and destroyed a hospital in Izum, Kharkiv region, while the patients were still inside. Overall, attacks on healthcare killed 100 and injured 129 people, impacting 580 medical facilities. Pillage of medical necessities was reported in all places where the Russian forces stationed even for short periods. In Mariupol, they seized ventilators and ambulances and moved them to Russia or Russia-occupied parts of the Donetsk region. In parts of the Kharkiv region occupied between February and September, 95% of all equipment was appropriated. Similar situation took place in Kherson. What appears to be systematic attacks and pillage of hospitals without a doubt may constitute relevant deprivation. Nonetheless, a range of evidence will need to be examined to illuminate how attacks on healthcare form part of the chain of causation leading to deprivation of Ukrainian civilians of OAS and NIH perpetrators' awareness of and proximity to the deprivation that occurred. Similar investigative approach will be required in relation to similarly systematic targeting of humanitarian aid distribution points, grain silos, farms, agricultural fields, grocery shops, and other food infrastructure. I will only give several examples here. On 24th March, Russian forces attacked a post office in Kharkiv, where civilians were queuing to receive humanitarian aid. As a result, 6 civilians were killed and 15 wounded. On another occasion, a restaurant cooking for the disaster relief organization, World Central Kitchen, was hit in an airstrike, wounding 4. In May, Russian attacks reportedly destroyed a grain warehouse in Sinelnikovo, Dnipropetrovsk region. In June, Ukraine's largest grain storage facility was destroyed by Russian shelling in the Mykolaiv region. Further, Russia reportedly pillaged grain elevators and other food storages, appropriating 600,000 tons of grain by June. A comprehensive report published in early October explains the logistics behind appropriation of grain worth at least $530 million and subsequently used to feed Russia's war machine instead of feeding starving civilians in Ukraine and countries that depend on Ukraine's wheat. The attacks went beyond destroying the already existing food to destruction and appropriation of the means of food production. Due to direct and indirect consequences of the war, namely burnt crops, inability to collect grains, mining of arable lands, as well as lack of fertilizer, pesticides, diesel, and worker shortages, the 2022 harvests are lower than before. About a third of the area normally available to Ukrainian farmers was inaccessible due to occupation by Russian troops. Close proximity of farmland to hostilities, landmines in fields, and damaged ordnance, tanks, and other material in liberated territories. All in all, Ukraine, a global major wheat grower and exporter, harvested 19 million tons in 2022, as opposed to 32.2 million tons the previous year. The next year's harvest is expected to drop by half compared to this year. As defined in the additional protocols, there is a wide range of actions that are capable of constituting deprivation within the context of starvation, including attack, destruction, removal, or rendering useless of such objects. As is plain, Russian forces committed all of these actions against the food infrastructure of Ukraine. The scale and frequency of such actions indicate that they were committed without a lawful purpose or in pursuit of a lawful purpose, but having adopted a criminal intent to starve civilians, which needs to be investigated. Lastly, I will briefly touch upon the issue of the recent missile and drone attacks, in particular those of the 10th, 17th, and 31st October, against critical civilian infrastructure objects. Although with deep gratitude to the armed forces of Ukraine, I must say that the map you can see is wildly inaccurate in the south. You can still see the sites of the 3 major strikes. This is not to say that energy and water supplies were not targeted before. However, it is the October attacks that caused severe damage of civilian infrastructures throughout Ukraine. The targets include power plants, electricity and water stations, some of which were destroyed beyond repair. While some argue that attacks against such objects assisted Russian military efforts, it's clear that many of them are unjustifiably remote from the front line and affect almost the entire civilian population of Ukraine, causing blackouts and water shortages throughout the territory. It would therefore be difficult to argue that such attacks brought direct and immediate military advantage to the Russian forces. Still time? Conversely, in the beginning of winter, when temperatures in Ukraine start dropping to negatives, damaging the infrastructure that provides heating, electricity, and water inevitably decreases the chances of civilians to sustain life. Let me start wrapping up and skip the intent section, given that this is an IHL forum rather than the ICL forum. It can be seen from the numbers of people in need of objects indispensable to survival, as well as patterns of the attacks that I've just described, as well as from statements of the Russian authorities and the propagandists that are associated with the Russian state authorities, that there might indeed be an intent to cause starvation of civilians in Ukraine. And every month, indicators of using starvation as a method of warfare by Russia become increasingly apparent. Many episodes of deprivation of OAS throughout conflict-affected areas start to fold into patterns, raising grounds to believe that the material elements of the war crime of starvation are satisfied. Therefore, an urgent investigation is needed to conclude whether indeed this crime is taking place and then prosecute all those who are responsible for it, which, if it happens, will be the first prosecution of starvation in an armed conflict in contemporary courts. Thank you.
Thank you, Anna. Perhaps we can elaborate more a little bit on intent in the Q&A to talk, specify what's at stake here. Our next and last speaker for this panel will be Shani Friedman. Shani is a PhD candidate and a research fellow here at the Faculty of Law at Hebrew University in Jerusalem. She teaches courses in international law here at the faculty and is the assistant academic coordinator of the International Law Forum. She researches various topics within the field of law of the sea, which is her main field of expertise. She researches international institutions and the intersection between international law and international relations.
Thank you, Tamar, and thank you to the Minerva Center and the organizing committee for inviting me to speak. So I will take you from the land to the sea. As Tamar said, I'm a scholar on the law of the sea rather than IHL, but I will try to talk about the situation in the Sea of Azov with respect of both IHL and the law of the sea. So first of all, as we all know and talked about here earlier today, on the 24th of February, Russia attacked and invaded Ukraine. You may or may not know that at the same day, it also suspended shipping in the Sea of Azov. And despite the negative effect on the world economy and creating a food crisis, this act did not receive much of scholarly and practitioners' attention. And I would like to analyze the legal situation in the Sea of Azov and the legality of the suspension of shipping. So this presentation or the paper had two main goals and one secondary goal, which is exploring the legal situation under IHL and mostly the laws of naval warfare, doing the same analysis with regards to the law of the sea. And as a secondary goal, which I do mostly in the paper rather than in this presentation, is asking whether the concept of naval blockade is relevant in modern international law. So I have a map of the Sea of Azov, the area. As you can see, it's a closed sea surrounded by Ukraine, Russia, and the annexed Crimean Peninsula. The Sea of Azov is connected to the Black Sea via Kerch Strait. The width of the Sea of Azov is about 85 miles wide, which means that both parties have maritime zones, such as territorial sea and exclusive economic zones in the area, which will be relevant later in this presentation. So the main question under IHL or laws of naval warfare is whether the suspension of shipping was in accordance of the legal regime of naval blockade. And here we have to ask what is naval blockade? So there's no one definition. However, the common ground or the accepted definition is essentially acting to prevent enemy and neutral vessels or aircraft from accessing areas under the sovereignty or control of the enemy. And the rules of establishing and enforcing a blockade is found in the 1994 San Remo manual, which for the purpose of this paper and the presentation, I will assume is reflecting customary international law, though we can debate on this assumption. So the first argument is that the suspension of shipping is not a naval blockade under IHL, since it's not meeting the criteria in the San Remo manual. First, Russia never officially declared a blockade, which is part of the necessary steps to establish a blockade. It was not effective or impartial, so the suspension of shipping was not completely suspension. Navigation to and from the Sea of Azov continued even at the height of the war. And now it's increasingly back to normal rate of shipping. Russia has not provided effective humanitarian corridors, and its action also led to a food crisis, which may also render the so-called naval blockade as unlawful. The second argument is it does not fall under the definition or the accepted definition of a blockade, since at least some of the areas in the Sea of Azov may not be under the control or sovereignty of the enemy or Ukraine in this situation. We have in 2014, Russian annexed Crimean Peninsula. Yesterday, we had a report in the news that Kherson was liberated, but the whole Kherson area was also annexed. You can debate whether it's a legitimate annexation or not, but it's also annexed to Russia. So at least some of the areas in the Sea of Azov where Russia has acted are not under the control or sovereignty of the enemy. However, we can say, as I said, it's under debate. Even in 2014, most of the international community did not accept it as annexation, but viewed it as a belligerent occupation. And if it's not a naval blockade, as I argue at least, the suspension of shipping is unlawful. It may be in accordance with the law of occupation if we accept that the situation is a belligerent occupation, as Russia can, as the occupying power, can take measures to ensure public order and safety. However, private property cannot be seized. So actions against private ships, commercial ships, is unlawful even under the law of occupation. So to wrap it up, the argument is that the suspension of shipping is not under the legal regime of naval blockade. It may fall under the concept of maritime zones. And first, we not confuse it with maritime zone under the law of the sea, which specify the rights and obligation of coastal states in different zones from their coast. But this is a common practice under IHL. You might know it is maritime operational zones or maritime exclusion zones, or as I call it, MZs in short. And it's a common practice acted in the Malvinas-Falkland situation, in the Iran and Iraq conflicts, and even in Gaza before Israel proclaimed an official blockade. It's a customary vague concept recognizing the belligerent right to control or prohibit access of foreign ships to relevant areas. However, even within these zones, the belligerents are still bound by the general rules of IHL, such as the principle of distinction. So seizing or operating against civilian ships or commercial ships is unlawful even under this concept. Some argue that the actions of Russia may fall under belligerent rights to control the immediate area of naval operation, which again also bound by general international IHL rules. So, for example, the principle of distinction. So this is the analysis under IHL. Now we may ask if the law of the sea has an effect on our legal analysis. And first we have to ask whether the law of the sea applies in times of armed conflict. And why we have to ask that? Because UNCLOS, or the UN Convention on the Law of the Sea, is considered to be a peacetime legal regime, and IHL as the lex specialis prevail over other legal regimes. So first, international law does not actually exclude the simultaneous applications of both regimes. And in addition, the San Remo manual itself is subject to the law of the sea regulation. So we can argue that the law of the sea is relevant to the analysis of belligerent rights in naval operation. And we have to look at the influences or the effects of this regulation even under IHL. So since 2018, there's 2 cases before international tribunals under UNCLOS between the parties, between Ukraine and Russia. Russia invoked the exception of military activities. And here, UNCLOS allowed the parties to exclude certain types of disputes from compulsory dispute settlement. One of these types are disputes concerning military activities. In both cases, tribunals maintained that the exception has not been triggered. And again, this is with acts before the war in February. So it's actions since 2014 and so on. However, the background of Russian conduct is broader than the armed conflict. And Russian vessels are not part of the armed forces and are not engaged in military activities. And while the tribunals refer to cases before the war, one of the decisions has been given in June 2022, which again, for me, is interesting to note the timing of the decision. However, what we can say is we are expecting to have a decision on the parties' maritime zones, which may affect the legality of Russia's conduct in the Sea of Azov. And it can be affecting in 2 instances. First, Kerch Strait can be considered an international strait. An international strait is a strait that allows navigation from one part of the high seas or EEZ to another part of the high seas or EEZ. And this applies in the Sea of Azov. As I said before, the wides of the Sea of Azov allow the parties to have areas that may be considered EEZs or the high seas. And it's also connected to the Black Sea, which also includes such areas. So if it is an international strait, every state has the right to transit passage. Every state has the right to navigation in the strait, and it cannot be suspended for any reason. In the territorial sea, the suspension of shipping can also violate the right to innocent passage, which is a narrower right that can be suspended mainly for security reasons. However, it must be indiscriminate. And as we talked about the criteria for the San Remo manual, impartiality and effectiveness, so here the same. We cannot say that Russia's suspension of shipping is indiscriminate, which violates the right to innocent passage. So again, if the Kerch Strait is in international straits, Russia cannot suspend shipping in Kerch Strait, which means to and from the Sea of Azov. The second effect of the law of the sea regards to the legal status of MZs. As I said before, parts of the area in the Sea of Azov and the Black Sea can be considered EEZ or the high seas. All states have freedom of navigation in these areas. So under the San Remo manual, the same body of law has to be applied outside and within the MZs. So if outside the MZ, all states have the freedom of navigation, within the MZs, all states have the freedom of navigation, and Russia cannot suspend shipping. So we see that the law of the sea here backs up IHL and also poses additional limitation on the suspension of shipping. And to wrap it up and conclude or compare the analysis I just made, I argue that the suspension of shipping in February 2022 is not a naval blockade. It may fall under a vaguer concept of practices of naval warfare, but is subjected to other rules of IHL. Here, the law of the sea significantly affects the legal status of the Sea of Azov and the legality of Russia's suspension of shipping, which adds more limitation on the ability to suspend shipping, which leads me to the conclusion or the observation that IHL, the perception that IHL is the lex specialis and prevail over other rules of international law may hinder any comprehensive analysis of belligerent rights and obligation at sea, which means that any analysis on these issues, at least I argue, that has to combine both legal regime to have a comprehensive view or comprehensive picture. And with regard to the secondary goal, so in the paper, at least there's a very few cases since modern international law of naval blockade. in most cases, they're not meeting the criteria of the San Remo manual, which we can argue two things. A, either the definition or the enforcement of blockades, the rules on enforcing of blockades has changed in practice, and we have to take account on that. Or the other option is that states prefer to downplay these rules and to apply softer, vaguer concept of MZs, which in this case leads me to the last conclusion that legal rules that are not applied in practice might not be considered legal rules since in accordance with the notion of the rule of law. Thank you.
So I'm going to open the floor to questions. We do have time for questions. I do have a few thoughts. Don't answer me. We'll take the questions, which are probably better than my musing. But first, I think... Take it. That we seem to come out of every panel here with a very similar conclusion that we don't really know what the rules are, and we don't really know how the rules apply to the current situation. And I think that's a concerning conclusion, or maybe concerning picture about what is going on. So two very general thoughts, and then we'll open the floor to questions. The first is something that came up, I think, both in Rochier's paper and in your paper, Shani, which is there seems to be a gap between military tactics or military practices that exists in this world of, of military practices and in the military manuals of, warfare, and the laws. And what we have is a convergence of various, legal regimes that might lead us to the conclusion that certain military practices that are very solid in the world of, military actions may not be lawful today anymore, or in any meaningful way, or in any practical way, or they may be theoretical, but we can't really use them. And I wonder, well, A, if this is the case, what does this mean about, these legal practices? And maybe what we're actually doing is outlawing them altogether. Rogier, you were very close to this, to saying that, seizures are limited to very, very specific situation, although, there are still theoretical scenarios. I mean, so I could say, well, what if there's a siege and you do allow, food corridors to come in, or humanitarian help? So you solved it by saying, well, then they wouldn't want to do it because they don't know if the foods go to combatants or to civilians. But assuming a state is willing to do that, is willing, to wage a siege and allow certain amount food quotas to come in. But they're still targeting civilians, even if not in starvations, right? They're still putting stress on civilians, and there's intent towards pressuring civilians. So how does this operate under the law of war? And Anna, this goes back to the question of intent, which you skipped, and now I offer you an opportunity to go back to it. So what is the specific intent that we look at, or we look for, when we talk about starvation, as opposed to, the general intent in targeting civilians? And what does this mean in this context, again, when we already have these very broad prohibitions on targeting civilian populations and targeting, civilian targets, in addition to saying, well, there's also this specific crime, what does this really mean today? Questions, thoughts from the audience?
Well, thank you for 3 great presentations. I think I can directly follow on the comments with a brief question to Shani. So I'd like to push you a bit more on what you said was going to be the second part of the paper, on the current relevance of concepts like blockade or maritime zones, for that matter, like all these ancient belligerent rights, so to speak. You mentioned rightly that nowadays the law of the sea has a role to play in naval warfare too. And I was just going to ask about the jus ad bellum. So would you say that rules like blockades, say, could permit you to do something that would amount to use of force? And how would that then interplay with the jus ad bellum? So can the rules still be good law from that perspective? Thank you.
Thank you. And I have a question, one for Rogier and one for Maria. Rogier, I agree with everything you said, and I think one of my challenges when looking at sieges is how to apply proportionality. And I, like you, agree that it's difficult to consider a siege as an attack and therefore apply the rule. The principle, and you said let's use the principle, but it's an ex ante assessment, even with regard to the principle. And it's just very difficult before you start off with the siege, knowing how long it's likely to last, whether the extent of the suffering for civilians. So it's very difficult ex ante to determine, well, not even to determine, to assess the incidental civilian harm, which makes me very uncomfortable adopting a siege as a whole analysis for proportionality. What's your thoughts on that? Maria, I wanted to react to your presentation because I think I'm trying to do exactly the same thing as you, to see how we can analyze the extensive discussion that's taken place in Ukraine in terms of impact on food security. And I think we've got to be quite careful about trying to shoehorn everything into the prohibition of starvation, and even more so in the crime of starvation. And I'm a little concerned that some of the elements that you were looking at probably don't properly belong within starvation and are best analyzed through other sets of rules. So, for example, you looked at attacks, destructions on healthcare facilities, saying these are objects indispensable, therefore they fall within starvation. And I'd say, don't overcomplicate your life. There's other rules that protect medical establishment that are already relevant. So let's look at those, particularly if we are aiming for a prosecution. And then with regard to starvation itself, I think we've got to be careful, because if you look at the provisions of Article 54.2 that prohibit the attacks, destruction, and so on and so forth, it's got to be for the specific purpose of denying the objects in question for their sustenance value to the civilian population. And I think before we look at the war crime, we've got to be quite clear as to what the underlying rule of IHL says. And it's really already got this requirement of a specific purpose. And I wonder whether in a number of the attacks you mentioned, we can actually determine this purpose exists. So I would say, don't complicate your life. They're violations of other rules. Don't shoehorn it into starvation.
Yuval, you wanted to ask, and then we'll do rounds of answers.
Yeah, thank you. I also join my predecessors in complimenting the panel. It was very interesting. And for your point, Tamar, about uncertainty, I will just say that we have selected some topics. I mean, there may be some topics which are less uncertain, which are more certain, but we didn't select them for the program. So there are some selection issues as well here. My question is really for all three of you about the issue of survival, the notion of objects necessary for survival. And I'm wondering whether this is a moving target. I mean, whether we are adopting today the same concepts of survival that were thought about in 1907, or do you see, from your experience, your engagement with the topic, a certain move? And maybe two areas in which such a move could be identified is one, the increased concern about reverberating harms that may have a particular impact in long-term siege situations, where and psychological harms being part of this picture. And secondly, from a different area of law, within human rights law, there is an increased attempt to, well, I don't know, you use the term shoehorn, Manu, but to capture within the concept of the right to life, also right to life with dignity, and to apply it specifically to environmental harms, and to basically maintain that under certain conditions of environmental harm, maybe physical existence is still somehow possible, but it's not a dignified existence. And I'm wondering whether this sort of analysis could have some currency in an IHL, ICL context as well.
We'll start from the same order of speakers.
When you were referring to a gap between military practices and the laws and question to what extent you mentioned the if you have a siege, the purpose of the siege is, of course, initially to take over that area, to gain control over the area. You could do, in practice, the same, doing the same conduct could have a different reason. You can try to lock in opposing forces within an area to prevent them from going elsewhere. The question is then, do you call it a siege? Because the whole idea of a siege is that you do that in order to enforce surrender so you can actually gain control of the area. But of course, if it's effectively the same conduct, then, but if your purpose is to lock in the enemy and to prevent them from fighting elsewhere, then a food corridor may work. In any other circumstance, if your goal is to enforce surrender, then allowing food in, then they'll just continue being in that city or village or whatever, and be able to continue to resist or at least not leave the area. So that seems to be incompatible with the idea of the siege or the purpose of the siege, unless of course there's actually a difference. In relation to that, and that's you mentioned there's the concept, of course, of collective punishment that could otherwise be a purpose for such an action, or the terrorization of the civilian population. Both are prohibited also under IHL, but then there will be a different purpose of that specific conduct. In answer to Manu's question, so if you do see a siege as an attack, it's easier because of course 57.2b requires you to cancel, to cancel or suspend an attack, also an ongoing attack, if at some point during the attack it turns out to be that the expected collateral damage would become disproportionate. But so if you consider the whole siege an ongoing attack, then at some point if it would turn out that the collateral damage, then you do have to seize it at that moment. If you do see it, so then the ex ante is not a problem. If you see the siege as a military operation to which then the principle of proportionality applies, which is how I would look at it, then with that and with the blockade, of course, you do have the problem like how do you apply the ex ante test. But if your operation is, and that's the goal, your military advantage that you want to gain is take over the area, and you know that the only way to do that is to completely starve, or at least force the surrender, because they would otherwise starve to death of whoever is in there, because you can't make a distinction in that sense between combatants and civilians. You know what the expected collateral damage is going to be. It is the starving of hunger of every civilian who's in there, unless you yourself, of course, would take precaution. And then there, the interplay is more, I think, between if you would then take, if leaving open a corridor for civilians to get out would be a precaution, for example, that you can take, and then the interplay between the two.
Distinction at that point, but wouldn't it be an indiscriminate military operation or attack?
No, okay, that's a separate. We're not talking about precautions, but yeah, obviously you're also not allowed for it to be indiscriminate. But then it would already be prohibited under that principle, and you don't even get to proportionality. And linked to that is, of course, the issue. What the whole goal is, of course, of trying to starve the population, which relates to intent that you were talking about. That regard, I actually had a question about your last slide because you referred to the possible lifting of sanctions. So then I wonder whether it's not more focused on third countries rather than of the Ukrainian population. So the intent, that statement wouldn't show an intent towards the Ukrainian population. As regard to Yuval's question, I do think it is a moving target. you can wonder nowadays, for example, whether internet is, I don't think so, but whether access to internet would be indispensable to the survival of a population. But the fact that you see that it seems that reverberating harms are now becoming accepted, at least the last number of reports on proportionality, it all includes, even the most modest version includes that the requirement to take that into account of psychological harm. So that is something that changes. It's a tricky thing though, because you have a sliding scale if you were to talk about a siege, where especially if a siege takes a long time. Like in Sarajevo, at some point, because you're not allowed to terrorize the civilian population, but the discussion has taken place in that regard. Something that would terrorize immediately a population in, let's say, the Netherlands. Just the fact that a bomb is dropped somewhere, they would all be, like, it would be severe PTSD or traumas for the, may not be traumatizing anymore for someone in Gaza or at the time in Sarajevo. So that, I wonder what, it needs to be context specific, but not too context specific.
Yeah, I'll be really quick. I do agree that not all of the incidents that I've mentioned may amount to the crime of starvation. And I think I said in the beginning that I'm not trying to argue that all of them do. What I was trying to do was to show patterns of conduct, and I know I bored everyone with the word patterns in the past hour. But it's really important, and I'm speaking from practical perspective because my primary job is to make Ukrainian investigators' lives easier. So from practical perspective, we do need to try and group these hundreds of incidents under a certain umbrella. And so as opposed to investigating 30-something thousand crimes, they only investigate 100 or 200 or 300. So one of these umbrella crimes could be the crime of starvation, if indeed the intent to starve civilian population is confirmed, which is why the whole purpose of documenting and investigating these incidents is to establish whether they indeed form the patterns of violations and whether they do form these patterns with an intent to starve civilians, even if the consequence does not occur, because the crime of starvation under ICL does not require the consequence. And so, of course, it's a specific purpose crime, and of course there are other crimes. However, I think that all possibilities need to be explored so that in the end we have the investigation and prosecution that is most reflective of the real factual situation. And yes, that slide, the last slide, was not the best example of the intent. I was coming to it. Russian Ministry of Defense actually admitted on several occasions that they are aware of the humanitarian catastrophe in several areas of Ukraine, which again in itself does not even show intent. But these speeches, the statements, the factual incidents, they do need to be documented so that in the end we have a clear picture and we know whether there is indeed a crime of starvation or whether there is a bunch of attacks on civilians or attacks on civilian objects and so on and so on.
Thank you. Shelley?
Thank you. So it seems that most of the questions revolve around the general question or issue of black letter law or rules versus practices. And I'll start with Alexander's question, which is specific, but go to the general, your comments and other comments, which is more general. So with regards to the relevancy of naval blockade. So when I started even basic research, there is no actual, or there are very few cases where I can compare the naval blockade practices. So the first thing I ask, well, if there are no naval blockade cases, what can I say about the rules? So, and with the terms of relevancy, we can look at it in both ways, as I said. One, that the rules are not relevant anymore because the practices have changed, and the other way is to say, well, the rules have changed. When naval blockade may be still relevant, but the way we see it or define and enforce blockades might be different. States have indicated that they want to change the rule through practice. It can also be through interpretation or opinion of institutions, as Yuval mentioned as an example. So we have an expansion of the law, or we have changes in the written law. International law is a living creature. It's not the same as it was in the 1950s or even in the 1990s. So it's the rules that are written in the treaties are changed by practices. And I can say it 99.9% happen across the board in all areas of international law. So it's not unique to naval blockades or naval warfare or even IHL. I show it in my dissertation in the law of the sea in one area, but it happens in all areas. So we have informal practices which can, if they are accepted, can become formal customary rules that switch or change the previous rules. So with regards to the occasion, I'm not an expert on the use of force, but if there is enough practice, which is not encountered an objection, then yes, it can go to that direction, but it can also go to other direction. It depends on practice. And when I say practice, it can be state action, it can be legal judicial interpretation, it can be institutional arrangements and all kinds of practices. So yes, that might happen, but it also can go in different direction. And yes, there are gaps between the rules and the practices in international law.
So we have 3 more minutes. One question if someone wants to. And short answers.
Yeah, for Roger, I think that if you were going to talk about the kind of viability or legal conditions related to siege, I think we have to take a broader operational view. I tend to disagree that the only context you'd see that in is one party trying to starve out the enemy on the other side. It's common practice to try and isolate forces in built-up areas and bypass them. So I think you'd have to consider whether a bypass operation would qualify as what you're characterizing as a siege. There's also the simple reality that as your resources dwindle, and I'm not talking about food and water, but ammunition and weapons, then your perceived combat effectiveness degrades. There's a higher probability of capitulation. The isolation of the unit itself will oftentimes be perceived as creating a higher probability of surrender, or sometimes you don't care. You'll just leave them isolated there. In all those situations, it seems to me that it may be more valuable to think in terms of the constant care obligation versus a kind of application of a proportionality concept to something that does not technically qualify as an attack. And that constant care obligation would be dictated in large measure by what the ultimate operational objective is. And I kind of doubt that you're going to have too many situations where the commander's ultimate operational objective is to kill the enemy by starvation. In most cases, it's going to be something far more limited. And in that sense, what you can do to mitigate the suffering of the civilian population that's commingled with that enemy opens up a lot more opportunities, as you say, in terms of offering the opportunity to evacuate or even allowing foodstuffs in where you can't control where they're going to be used, because you don't really care if the enemy's eating. You care about the psychological effect on enemy leadership, knowing that they're completely isolated and have no opportunity to rejoin their other forces.
Do you want to quickly respond?
Yeah, briefly. Of course, the legal discussion as to legality of sieges then depends on what you qualify as a siege. And if you take then the definition, which assumes that the area itself, it's about gaining control over the area, then I think that makes a difference. In practice, there may be different objectives, and it can change also in a situation. Like in the time of before July 1995, the purpose in relation to Srebrenica was to lock in the forces there to prevent them from joining the fight elsewhere and to, for example, to reach Sarajevo. But then towards the end, it was control of territory because the peace agreement was coming and the VRS tried to have as much territory as possible. So then it became takeover. So yeah, the objective may change, and then obviously that has an effect. And when I talked about starving the situation, the ones there, the objective is not, of course, to starve them to death. The objective is to force surrender. But one of the ways would be that you're accepting, if you're employing a siege in the classic sense, you're accepting that if they hold it out long enough and they refuse to surrender, it would ultimately lead to them starving. Unless, of course, at some point you just end the siege. But I agree, it is, of course, we try to now isolate it for a legal discussion, but it involves a lot more consideration.
Thank you all. Thank the participants. We can take this discussion further during coffee. We have a coffee break. So thank you very much.